death during the divorce proceeding, of course, and many of you family law practitioners out there know even closer what happens for you on a divorce perspective, but I'll just go over these general rules too for some of our estate planning practitioners that may be on the webinar. In many jurisdictions, the death early in divorce proceedings immediately terminate a dissolution. And this can often be referred to in some states as abatement. But then as divorce proceedings go on, as to whether or not the divorce proceeding itself is abated may differ from state to state. In Minnesota, for example, even a signed mediation agreement, if it had not yet been approved by the court, would not be considered enough for the court to continue on with the divorce proceeding. Retroactive divorce, that would be something where an individual dies during divorce and the court continues the divorce anyhow or honors the divorce. And in this, that's pretty rare where the court will allow a divorce after the death of one of the spouses, but, and for instance, in Minnesota, there has been a case long ago, but that was due to judicial error where they did not enter the divorce when the divorce actually had issued findings of fact, conclusions of law, and an order for judgment in that case. A bifurcated dissolution is coming up more often now, and many of you probably know a recent trend has been for the court to issue a partial decree early in the dispute to sever the marriage and then leaves other longer-term issues such as valuation, non-marital claims, and final division of assets for further consideration. Some jurisdictions have held that if one spouse dies at this stage, the dissolution will continue even if the spouse dies. And lastly, there is a post-decree relief and appeal process. Those are okay after death also in many states.